So we're going to start this off real quick with an exclusive, baby, from my boy, Bryson Boom Paul, man. Y'all go give him a follow over there on Twitter, all right? On the deal and ruling, Haddad said, this is basically Nacimiento and Haddad being YNW Bortlen's lawyers, all right? So on the deal and ruling, Haddad said, feel good for the kid. I've been on the case 6 years. It's a fair resolution for him. The state was fair. On what Bortlen will serve, Haddad said he gets 1,000 days and another one, he gets 700 days. On the message this sets for Melly's case, Haddad said, there's no message that I see. They're two different people, two different cases. Facts are different for both. On what Bortlen will have to do and will have to testify against Melly, Haddad said a couple of questions, that is. He's not going to be a witness. On did Bortlen admit to the crime with a no contest plea? Nacimiento said, I think it is important to know that one, today you did not plead guilty. He's played no contest. I think he meant to put he pled no contest. And so he hasn't really admitted anything. And there is no anticipation that he's going to be called. He has a witness by the state or the defense at the Melly trial. So nothing that happened today or will happen in the future, I think, will change. Importantly, he hasn't admitted anything. So although the court found him guilty because of his contest plea, no one could say that he has admitted that he committed tampering or accessory after it's certainly not murder because that was dismissed. On why accepting a plea 24 hours before the trial, Nacimiento said, I think just naturally that happens in these types of cases. Both sides are putting in a lot of work. Fred's been working on this for 6 years. The parties, you are ready to go, but we all know the strengths and weaknesses of the case. Haddad added, the state knows what their strengths were and what our strengths were, and that's how you resolve it. I've got the same thing going on in other places. You know, we resolve cases before trial, sometimes with a favorable outcome. I prefer to be in trial, but what are you going to do? There are some things you can't turn down. The state said we're going to drop 2 counts, the first-degree murder, if you want to resolve it. In order to plea, people have to do jail time, but the alternative is very difficult. Remember that whenever you plead to something, you got to do jail time. Nacimiento concluded, yeah, Cortland's 26 years old. With this resolution, he could be out at 30, 31 years old. If he's found guilty of one of many of those counts, and would have been mandatory, I'm assuming he meant to put that would have been mandatory life. So, just on balance, you look at that, and someone in his position, it's a hard decision to make. Regardless of what you think about your chances of trial, regardless of how strong your case is, you're looking at life. It's multiple counts in 2 different cases. Haddad concluded with the following. Every lawyer can tell you horror stories. Cases you thought you couldn't lose, that you'd lose. Case you couldn't win, that you win. It happens all the time. You can't figure out a jury. We had to start it off there because there are lies already being disseminated by the public to the people who want to push whatever they want to push. Never intellectual ideas, just opinions based off of feelings. But let's go.
All right, so Mr. Henry, it's 2 cases, sir. I'm going to go one at a time. In case number 19-1871 CF10A, this is before the agreement you made with the state, before the deal you made with the state. You were charged as follows. Counts 1 and 2 is murder in the first degree with a firearm. Those are capital offenses. The maximum and mandatory penalty is life in Florida State prison. Counts 3 and 4 are accessory after the fact to murder in the first degree. Those are each first degree felonies. The maximum penalty is 30 years in Florida State prison. In case number 23-10643 CF10A, you're charged at count 1, tampering with a witness in a capital felony. That is punishable by life in Florida State prison. Count 2, directing the activities of a criminal gang. That's a first degree felony. Again, punishable up to life in Florida State prison. Count 5 is conspiracy to commit tampering. Again, as it relates to a first degree murder charge, that is punishable by a maximum penalty of life in Florida State prison. And count 7, unlawful use of a 2-way communication device as charged. That's a second degree felony. The maximum penalty is 15 years in Florida State prison. So, sir, again, before the agreement you made with the state, before the deal you made with the state, your maximum exposure here was life in Florida State prison, followed by 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 75 years in Florida State prison. Sir, do you understand all the pending charges and the maximum possible penalties involved? And it's my understanding that you want to resolve both cases today. Is that correct? Yes. And that resolution is an agreement you've reached with the state, the terms of which are as follows. Number 1, in the 19 case, you're going to plead no contest to both counts of accessory after the fact. In the 23 case, you're going to plead no contest to all 4 counts as charged. In exchange for that, the state is going to null process, that is, drop the 2 first-degree murder counts. All right, I'm going to adjudicate you guilty. Yes, sir. What's happening with that?
That would be no problem.
So he's only going to plead to the tampering with a witness in a capital felony, conspiracy to commit tampering and unlawful use of a two-way communication device?
Just the tampering and the unlawful use.
Just count 1 and count 7.
Correct.
State you're going to null process count 2 and count 5.
Correct, Your Honor.
As it relates only to Mr. Henry.
Correct.
Okay. So Mr. Henry, what it's going to be is 2 counts of accessory after the fact, tampering with a witness in a capital felony, and unlawful use of a two-way communication device. In exchange for that, I'm going to adjudicate you guilty on the 2 accessory counts as well as the tampering count. I'm going to sentence you to 10 years in Florida State Prison. That will be followed by 6 years of reporting probation. In the unlawful use of a two-way communication device, that's a second-degree felony. The maximum exposure.
It's a third degree, Your Honor.
It's a second as charged, I believe. It's a third, except as it relates to a capital case. But I'm happy to
Ours
look it up.
has a third that we discussed.
I want you to pay attention to that part right there because he literally says accessory after the fact. That's very important because there are individuals right now that are trying to spin this like it's going to hurt YNW Melly. It actually helps YNW Melly. But don't worry. We're going to break it all down for you. Let's continue on.
Well, what did you want the negotiated sentence to be for that?
That was just going to be the maximum of my term.
5 years? Is that what you want me to do?
Correct, Your Honor.
Okay. All right, so, sir, as to that count, it's going to be adjudication of 5 years in Florida State Prison. So the 2 accessory counts as well as the tampering count, those come with 6 years of reporting probation after the Department of Corrections sentence. I'll give you credit for all the time that you've served in both cases. All of those counts will run concurrently. All those sentences will run concurrently. All counts in all cases, that is at the same time with each other. I'm going to have to impose mandatory court costs. I'm going to order restitution payable to Terry Bagley and payable to Ashley Phillips and reservists of the amount. I'm going to give the state 120 days to tell me the amount of that restitution. If they fail to do so within 120 days, there will be no restitution. If they come back with an amount and the attorneys agree on the amount, I will impose that as another condition of your sentence to pay back that restitution. If they come back with an amount and the attorneys do not agree on the amount, I will conduct a restitution hearing. Sir, lastly, and I want to make it very clear on the record, and it's unrelated to this negotiated change of plea, I guess at some point after the fact, the state wants to take a proffer from you or have a discussion with you, ask you some questions about whatever that may be. What I want you to understand, sir, is I guess that's part of this negotiated resolution, but your answers to any of those questions, whatever they might be, have no bearing on me and have no bearing on this negotiated resolution. In other words, the deal you've negotiated is the deal you've negotiated, and that's the ballgame. Do you understand all that, sir? Have you had enough time to talk to your lawyers about all that? They've answered all your questions? You're sure that that's what you want to do? Because I want to emphasize, Mr. Henry, and I'm going to do this again at the end of my plea colloquy, whether you resolve the case by way of a negotiated plea or an open plea to me, or you resolve the case by way of a trial, it doesn't matter to me at all. But due to the resources that have been devoted to this case, I have 250 jurors summoned for jury duty starting tomorrow. So I want to be very thorough with you here this afternoon because if you wake up tomorrow or the next day and you decide you've changed your mind and you want to resolve this case, both cases, by way of a jury trial, that's not going to happen. All right? If you want to have a trial, the trial starts tomorrow. If you want to accept the deal, you can accept the deal today. But there's not going to be any buyer's remorse, in other words, because I've given you plenty of time to think about this, talk to your lawyers about it, talk to your family about it. I talked to you about it last week. Kind of looks like your lawyers probably did something or other to get a better disposition for you as of this afternoon, but this is it today. So understanding all that, you've had enough time to talk to your lawyers about all that, that's what you want to do? So, sir, has anyone forced you, threatened you, or coerced you into entering these pleas? If I accept your pleas, there will not be a trial in either one of these cases. Do you understand that? If I accept these pleas, there's a whole bunch of constitutional rights you are giving up. I want to make sure you understand all of those rights. You have the right to maintain your plea of not guilty and have a trial in each case. You have the right to present defenses, to file motions and other pleadings in support of your defense. You have the right to remain silent. You have the right to have the state prove you guilty beyond a reasonable doubt. You have the right to confront and cross-examine the witnesses against you. You have the right to appeal any decisions that I may have made up to this point or any rulings I might make in a future trial. But understanding by entering this negotiated resolution today, you are giving up all of those rights. The matter is going to be resolved today, right now, this afternoon. Is that what you want to do? Are you satisfied with your lawyers? Have you had enough time to speak with them? Have they answered all your questions? Are you satisfied with all the work that they have done for you? Sir, I've got 2 identical plea forms here entitled Plea of Guilty or No Contest to Criminal Charges in Circuit Court. Each one has your name on the top, your initials on the left-hand side, front and back, and your signature on the back. Did you go over both of these forms? Any questions about what's on either of these forms? And is that your signature on the back of each form? Sir, there's a few things that I need to tell everyone that I take a plea from. They may or may not apply to you. If you are not a citizen of the United States, these pleas will result in your deportation. Do you understand that? Under the provisions of the Jimmy Rice Act, if the offenses to which you are pleading are sexually violent or sexually motivated offenses, or If you've been previously convicted of such offenses, then these pleas will subject you to an involuntary civil commitment as a sexually violent predator upon completion of your sentences. Do you understand that? If these are drug offenses, the Department of Motor Vehicles will revoke your driver's license for a period of 1 year. Do you understand that? Sir, paragraph 11 of each form that you sign reads as follows. I acknowledge that my attorney and I have reviewed any discovery disclosed by the state. My attorney and I are unaware of any physical evidence for which DNA may exonerate me. In other words, sir, if there's any physical evidence in the case that we could test for DNA, that DNA evidence would not tell me that you were not one of the people in that vehicle when these crimes occurred. But actually the opposite would be true. If there was any such physical evidence that could be tested for DNA, that DNA evidence would tell me that you were one of the two people that was inside this vehicle when these crimes occurred. Sir, do you agree with that statement? State, do you agree with that statement?
Yes, Your Honor.
Defense, do you agree with that statement? Mr. Henry, understanding everything that I have talked to you about up to this point, do you still want to go ahead and resolve both cases today, right now? Defense, is he stipulating to a factual basis for the purpose of each plea in both cases?
Yes.
And if he's entitled to a PSI, defense, are you going to waive that as to each case?
Absolutely.
State, is there anything else that you need me to do before I take his plea?
No, Your Honor.
Okay. So, Mr. Henry, again, two cases. We're going to do one at a time. In case number 19, 1871 CF10A, as to count 3, accessory after the fact to murder in the first degree, and as to count 4, accessory after the fact as to murder in the first degree. How are you going to plead, sir? Guilty, not guilty, or no contest? In case number 23, 10643 CF10A, as to count 1, tampering with a witness in a capital felony, and count 7, unlawful use of a two-way communication device. How are you going to plead, sir? Guilty, not guilty, or no contest? I will accept your no contest pleas as to each. I'm going to find a factual basis to support each based upon my review of each electronic probable cause affidavit as well as your stipulation in court here today. I'm going to further find that you have freely, voluntarily, and intelligently waived your rights, that you have knowingly entered each plea with the advice of competent counsel who you've told me that you are satisfied with, that you understand the nature of the charges and the consequences of the plea. Accordingly, and pursuant to the negotiated agreement, I will sentence you as follows. In case number 19, 1871 CF10A, as to count 3 and count 4, I will adjudicate you guilty, sentence you to 10 years in Florida State Prison. That will be followed by 6 years of reporting probation. I will impose mandatory court costs. Pursuant to 943.325, I will need a set of your prints and DNA. Pursuant to 938.27, I will impose a cost of prosecution of $100. Sir, I'm also ordering restitution in that case payable to Terry, T-E-R-R-I Bagley, B-A-G-L-E-Y, and Ashley, A-S-H-L-E-Y Phillips, P-H-I-L-L-I-P-S, and reserving as to the amount. I'm going to give the state 120 days to tell me the amount of the restitution. If they fail to do so within 120 days, there will be no restitution. If they come back with an amount and the attorneys agree on the amount, I will impose that as another condition of your sentence to pay back. If they come back with an amount and the attorneys do not agree on the amount, I will conduct a restitution hearing. That will conclude that matter. In case number 23-10643 CF10A, as to count 1 and count 7, I will adjudicate you guilty. Count 7 is a sentence of 5 years in Florida State Prison. Count 1 is a sentence of 10 years in Florida State Prison, followed by 6 years of reporting probation. I will impose mandatory court costs in that case as well. I will not impose the cost of prosecution in that case as I just did so in the previous case. Pursuant to 943.325, I will need another set of your prints and DNA. All of these, there is no restitution in that case. All of these sentences, all counts, both cases, will run concurrently. That is at the same time with each other. I will give you credit for all the time that you have served. State, in 1871 CF10A, your announcement as to counts 1 and 2.
The state will be announcing a null process to those counts, Your Honor.
And in case number 23-10643 CF10A, state your announcement as to count 2 and count 5.
The state will be announcing a null process to those counts as well.
Okay. I think that concludes all the matters. State, is there anything else that you need me to do regarding Mr. Henry in either case?
If you just have one moment.
Oh, already, and I want to read this right. I want to make sure I read this right. It says, and this comes from academics, bro, and you real life pissed me off on this one. It is what it is. YNW Bortlen takes a gunner plea, meaning he pleads guilty to accessory to murder, which basically confirms and will be used against YNW Melly that a murder was committed and he was part of it. YNW Melly's whole defense was that he wasn't in the car or didn't murder his friends. This plea severely cripples his defense, and Bortlen will serve 16 years in prison as opposed to face life if he had taken the murder charge to trial. No, he got 10, bro, with 6 on probation and time served, bro, which means he'll be out in 8 years. So you're dead ass wrong in that part. Let's destroy everything you just said. First off, he pled guilty to accessory after the fact. That's very, very important so that people like you should know what the hell you're talking about. Because YNW Melly's defense is we weren't in the car when the murder happened. Which means what YNW Melly and his team will be doing is blaming Bortlen for it. Because Bortlen already played out. So the state can't come back and basically take it away. So if something happens to the bodies afterwards, and I say I was never there, that wipes the whole entire thing out. So what are you talking about? Bro, that's like me saying, you know what, bro? Hey, me and my brother, we got arrested for a house fire, right? And my whole thing is that, bro, I didn't commit the house fire at all. My brother pleads and say, yeah, bro, at the end of the house fire, bro, I did try to cover up the tracks on the damn thing. He never says I did it. Does that mean that you gonna sit there and say, well, since Nash, you saying you basically left the house before the house fire started, that you were part of it too? What are you talking? This is the stuff that you people try to make everything basically snitching and all this stuff and everything like that. First off, Gunner's plea deal didn't hurt the case. You heard it out of Young Thug's mouth. Young Thug basically lied and said, oh, I was going to get found guilty on the drugs and on the guns. That's BS because it wasn't in your possession. Your lawyer could have fought that. That wasn't even true. You really tapped out because there were phone calls that were about to come out and there were witnesses who were about to take the stand. If people want to go look at that witness list, you know exactly what I'm talking about. So nah, bro, we don't want to sit here and hear none of that BS. You're lying. You flat out lied. YNW Bortlen is not testifying. YNW Bortlen's freaking plea deal is not going to come in because it's useless. Because it's freaking useless. He took the best plea deal he could get. And not only did he do that, his lawyer went in there, shirt bust all open and basically dripped vodka and Hennessy all over that place and did his thing, bro. Shout out to that lawyer too, man. So nah, man. YNW Bortlen beating this was dope. Because at the end of the day, he obviously had something to do with the cover-up. Maybe he just too street. This is what happens when you don't yap your mouth, when you don't open up, when you don't say anything. So it is what it is. YNW Melly actually has a chance of beating this now more than ever, because basically they're saying that they have the basically they're saying they had a person that they could throw under the bus and everybody would understand it. The streets will understand. Damn, YNW Melly just threw YNW Bortlen under the bus. Dang, bro, why would he do that? Because that's how the plea deal is set up. The plea deal is set up for Bortlen to be the scapegoat. Didn't know you cats didn't understand that. But you want to win this right here? Subscribe right now. Comment right now. Like right now, bruh. And you good to go. Other than that, click right here to see that damn tape that Drake basically was told to go after Gunna. So was Lil Baby. So was Lil Durk. The album was going to be crazy because Young Thug's Business and Business album basically stopped. But click right here to see exactly what the hell I'm talking about.